Hello, my name is Daryl Coates and I'm the Tasmanian Director of Public Prosecutions. This position is often referred to as the DPP. My staff conducts criminal trials in both the Supreme and Magistrates Courts throughout the state, and we rely heavily on witnesses in order to do this. My prosecutors act on behalf of the state of Tasmania and do not act as the lawyer for a victim or witness. I do realise though that the process of being a witness can be quite stressful for people. For this reason, I've employed witness assistance staff throughout the state in order to provide support and to help people through the legal process. The purpose of this video is to provide an overview of the key points about being a witness and giving evidence. If there is any further information that you need or support that you require, I would encourage you to contact my office and speak to a member of my witness assistance staff.
There are two types of notices that are sent out. Read the notice carefully to see which type it is. The first is a preliminary notice. This is sent to alert witnesses to the fact that a case is about to commence in court. You do not have to attend on that date. The second notice is a final notice. It is essential you appear at court on the date and time specified. If a witness does not appear, it is possible the judge could order a warrant for the arrest of the witness. If there is an urgent reason that you cannot appear, then it is important to tell the court and provide supporting documentation such as a medical certificate. It is also possible that you will not receive a notice but simply be contacted by a staff member from the DPP's office to arrange for you to give evidence. Witnesses are normally asked to attend the DPP's office for a meeting to discuss their evidence. This includes meeting with the prosecutor to go over the statement and prepare for court. It can also include a court tour. Dates and times for appearing in court will be given. If you think that you could benefit from counselling to help get you through the process of giving evidence, then raise this with a witness assistance officer or prosecutor. Courts have security officers and you should let them know that you are a witness as you go through security screening. Allow enough time to get to court, arrange parking, etc. If you have any concerns about safety or cannot afford to get there, you should contact a witness assistance officer to assist you and take you to the waiting area. Before entering the courtroom, you should ensure that your mobile phone is turned off. Witnesses are not allowed in the court before giving their evidence, and it is important not to discuss your evidence with other witnesses before you go into court. Take something to read or do while you are waiting to give evidence, as delays can occur. You can also take a copy of your statement to revise before giving evidence, but do not take it into the courtroom with you. When your name is called, you will be shown into court and directed to the witness box. While standing, you will be asked if you would like to take an oath or an affirmation. Both options are equally valid. The oath is a religious promise on the Bible or Holy Book, and the affirmation is a non-religious promise to tell the truth. If taking the oath, you'll be asked to say, "I swear," and if taking the affirmation, you'll be asked to say, "I affirm." The judge or magistrate should be addressed as Your Honour. In the Supreme Court, the judge and lawyers will be wearing wigs and gowns. Take your time and listen carefully to the questions. Speak slowly and clearly and answer honestly. If you don't understand a question, say so and ask for it to be put in a different way. If you don't know the answer to a question, then it is valid to say so. Try to be calm and patient, even if your evidence is being challenged. If you are feeling very stressed or tired, you can ask the judge or magistrate for a break. The court will pay limited expenses for travel, contribution to loss of work income and so on. Speak to the DPP staff member about this. In some cases, it may be possible to give evidence from another room and have a support person sit with you when giving your evidence. Speak to the prosecutor or witness assistance staff member about this if you think it would be appropriate for you. This applies particularly to children, victims of sexual assault, victims of serious violent crime, and people with a disability. If there is any reason that you might find it difficult to understand the questions in court, such as English not being your first language, literacy issues, or having a disability, speak to the DPP staff about this so that arrangements can be made to modify the questioning process. If you have any questions or concerns about being a witness, please ring the Office of the Director of Public Prosecutions to discuss with the Witness Assistance staff member.